Okay, everybody, this would be discussion board number 3 for juvenile justice. Starting out kind of looking over the comments in your lecture overview. One of the things I think is important to consider is that just like your comments say, there's no separate juvenile justice or juvenile legal system mentioned in the Constitution. Nowhere is it mentioned until about 1890s, when it started to be a consideration, especially in Chicago, as many of you have already found out, and I've seen in some of your discussion comments. Up until that time, through the 18th and 19th century, understand that women and children were basically property of the father of the family, and anything could be done depending on his attitudes and belief systems. So for instance, if a child would backtalk to a father, the father could kill that child for no reason. So there was no real reason for the court system to get involved in the eyes of many people. Now, other things like orphans and things like that were primarily handled by the churches. And so basically there was kind of a hands-off attitude on dealing with kids. But as times passed and it became less an agrarian society or farmland society and more of an industrialized society, we saw children like roaming freely, with no direction, or we even saw children maybe 12 years old that were working in these factories. So it was one of those situations where a lot of this has developed with modern times. So this whole idea of a juvenile court kind of developed with modern times. Well, what ended up happening then, a juvenile court was formed in order to avoid some of the problems that they were seeing, mainly do-gooders in society, let's put it like that, progressives in the 1890s especially. We're talking about children being put to work in these factories, literally chained to machinery. They had chains on them, on their ankles, and if the factory would burn down, they would burn up. Same thing, if they weren't working, they're out roaming around, they could get into trouble, stealing and things like that. And so they'd be put in prison with grown-ups, and then the adults, prisoners, would abuse the children. And so there was just this concern that children would be abused in the adult legal system. So they started separating them out beginning in around the 1890s. Well, one of the things that came about with that, though, is when they created this separate system, they had no idea, nor did they believe, that it was necessary to preserve the legal rights of the child. They didn't even really think about that, because up till that time, children had no rights. But more and more they started to see that there were issues that were developing on this. And we see this case of Gerald Dawalt, which is my main favorite case, and there's a number of other ones we're going to talk about here in just a couple minutes, but that's the one that to me is just like the overall most terrible of these cases, because he was given pretty much a kangaroo court. There were no witnesses, there was no testimony. Judge just heard the police report read to him in a hearsay fashion and just accepted it, and it was for making obscene phone calls, for goodness sakes. And this young man, Gerald Dawalt, was sent away to a boys' industrial school, which is tantamount to prison for kids, based on this rinky-dink kangaroo court type situation. And so that resonated all the way up through the legal system. There was one little old spinster lady lawyer down in Arizona that took this case seriously, and she rammed this thing all the way through. And you'll see a picture of her with Gerald as an adult. And it's so interesting that Gerald, we gave him his rights, and he got out, the case was over, and what did he do? He joined the United States Army. He served with distinction in the United States Army all through those Vietnam years, became an E7, which is almost the highest rank that you can get in the Army. was honorably discharged from the Army, and lived a quiet adult life. So you want to talk about an injustice that had been done. This is the case, and that's why I make such a point of that in setting up the discussion as I did. Now, as we walk down through what we have here in Module 3, you can see that there's a number of cases here in blue that you want to look at. Here's Kent versus United States. There's another important case. It's a 1966 case. Talks about the essentials of due process, that children, youths, young people are entitled to the essentials of due process even though they are in juvenile court. This is important to me because when I started out in probation, one of the first things we did, we had to do like continuing education. And part of that was going around to different courts in the area nearby and just see how they do things. And a lot of these courts back then in the 70s still, even though there was Kent versus U.S. and Dawalt versus U.S. and a number of these In re Winship and these type of things, they didn't follow it yet. It took years for this to take a hold in the counties after the Supreme Court came out and said this is how it's going to be. And so basically what ended up happening, I witnessed this same thing that was going on in Dawalt. It was all a sham of justice. There was no real justice involved in it. So in Winship, it's the essentials of due process are the key words. In Dawalt, as I mentioned, 1967, that followed Kent, we talk about any hearing that could result in a commitment to an institution. Juveniles have the same four basic constitutional rights that adults do. Basically, the Miranda rights. Lawyer, right to remain silent, right to call witnesses, that is subpoena witnesses, right to cross-examine, right to face their accuser. All of this is essential for this to be a truly just and due process type hearing. In re Winship is another one. It says in delinquency matters, state must prove the case beyond a reasonable doubt. I mean, they weren't putting on any proof in the Dawalt case, if you notice. Same thing in Winship. I mean, basically what they did, they just would read a police report, and that would be it. That would be the whole hearing. Read the police report, that's it. Policeman didn't testify, which all the policeman could testify is what some other witness told them. So victims didn't have to testify, and so that was it was mainly just an outrage. And so finally, over this period of the 60s, they made some substantial changes up till 1970 in just providing the basics of due process in juvenile court. Yes, in the sentencing phases of juvenile court, we had started taking people, young people, children, out of adult prisons. That was the whole idea, the intent of the creation of juvenile court. But in a way, it's putting the cart before the horse, because we were taking away their rights and then we were giving them a lesser punishment. That was the philosophy or the idea of what they were doing. But this was not constitutional. It's just not allowed. And so that was an important problem or fallacy with this whole process. So as we look down these other cases, McKelver versus Pennsylvania, 1971, no jury trial allowed in juvenile cases. The jury trial is the least protected right in the Constitution. Many, many cases will tell you that. And so it's not surprising that in juvenile court there's no jury trial. If you want a jury trial in juvenile court, you've got to ask yourself to be waived up to adult court. Another important one, Breed versus Jones, 1975. Waiver after having been found to be delinquent is double jeopardy. Okay, so basically what we're saying is if you're going to waive somebody to adult court, you got to do that in the beginning. You can't get all the way through the case and say, well, I'm going to change my mind, I'm going to just waive them to adult court. You can't do it. That's two trials for the same case. So you can't do that. If you're going to have a waiver, it's got to come first. And so some of these laws that we're seeing that I hear some of you mentioning, I really want to look into them a little bit more, because I'm thinking that there's an issue there with that. On this same thing is, you can't, you go through and you find a child delinquent and you send boys school, and then you say, but after you're done with boys school, we're going to look at whether we ought to send you to prison. Well, you can't really do that. I mean, because of that same double jeopardy ruling, and the case that says that is Breed versus Jones, and that's a 1975 case. Other important cases: Oklahoma Publishing, Smith versus Daily Mail. These are 70s cases too, 77, 79. Press may report juvenile court proceedings under certain circumstances. More and more they're saying that juvenile courts are just open to the public. When I worked in the system a lot in the 70s, 80s, 90s, it was never open to the system, to the public. It was a closed system. Basically, if you wanted in, you had to have a good reason to be in there. Now, we allowed some students in there for internships to just view what goes on in juvenile court, some special things like that, but the newspaper was never allowed. So that was a big thing to consider. Quickly, the other cases: Eddington versus Oklahoma. Youthful age should be considered as a mitigating factor in deciding whether to apply the death penalty. In that particular case is a precursor to the most important case, which is not even on this list, which is Roper versus Simmons. You can look that up. U.S. Supreme Court case says nobody under 18 is going to get the death penalty. So there's a series of cases: Atkins versus Virginia, a number of these other cases that say no juvenile under 18 will get the death penalty, period. No death penalty for juvenile, even no matter how heinous the murder case. So that's just a saying that the juvenile brain is not developed enough until they reach the age of 25 to really understand the wrongfulness of their actions fully, and therefore there is no death penalty for murders by minors under 18. Other one besides that is Shaw versus Martin. Preventative pretrial detention is allowable. There is no bond in juvenile court generally. No bond. So in other words, you cannot post a cash bond and get out of juvenile court. How is that important? Well, frankly, if a child is waived to adult court, they're entitled to bond. And a lot of times prosecutors are so poorly informed and really dumb that they don't realize that really a waiver of a juvenile in some cases is playing into the juvenile's hand. It may not be in the juvenile's benefit, but you're going to put the juvenile in a position where somebody can bond them out. They get out of jail. So basically that's something you don't want to cause in some cases. Just being locked up for their own protection is a good idea. And so that's something that you want to consider. Other cases: minimum age for the death penalty. Here again, this is an older thing. Talk about Thompson versus Oklahoma, Stanford versus Kentucky, but those have both been swept away by Roper versus Simmons, which now says, which I think is a 2003 case, that says that there is no death penalty for juveniles. So basically, some things to consider, not even included in here. Look these all up and give us a good response in your discussion board. Appreciate what you've been doing up to now. Hang in there. Always feel free to get hold of me if you have questions. Thank you. See you on the next one. It's signing off, Rob Dawalt.